Attorney Macy, Mike Durr calling. So we are in our budget meeting in the Village Hall. The board is here short of Trustee Kalinsky. He had to leave for a previous appointment. All four of the trustees separately went down and looked at the property. We're having a lot of discussion about that. So there's a few people in attendance today. So I'm going to put you on a speaker and then put the microphone down by the speaker so that they can hear over the PA. And the main part of our conversation is conversations that you and I have had in the past since I've been on the board about how and the legal issues that go along with the purchase of public property, and then also the issues that go along with bidding a public works project that would involve a building, and how it becomes difficult if you want to do like a Morton building or a Menards building or a Walters building or something that is a bit prefab. So you are on the PA. So do we want to start with the purchase of public property?
Certainly. Good afternoon, everyone. I apologize for not being able to be there. It's not that I couldn't have been there now, I just can't get back here to my 6 o'clock regular meeting, and so we're doing this. This accommodation was made at my request, and thank you for the same. What we're speaking of is when a municipality wishes to acquire property, particularly real estate, the laws that apply in the state of Wisconsin. And there's a lengthy history here. I'll keep it very short in that when all the corridors, mostly in Milwaukee County, all the lands were acquired for the corridors, many of which were never built, the freeway corridors, the takings of those properties was highly questioned by the legislature and the individuals. And since that time, the pendulum, as we like to say in this instance, swung way, way over toward the other side, and it makes it very difficult for municipalities to acquire real estate. And it's firmly believed by most, if not all, municipal attorneys that condemnation is the only way that a municipality can acquire property. And to acquire property by condemnation, you must go through the condemnation process. And I'll detail just very quickly. That process begins with initial resolution of intent to condemn by the governing body. Then there's a right slip that's spelled right out in the law, pamphlet that has to be given to the property owner. Then the appraisals are given to 1, 2, or 3 appraisals. Then you negotiate a price. If you can't agree to a price, you make a jurisdictional offer. The person accepts the jurisdictional offer, or if they fail to accept the jurisdictional offer, you condemn the property, you set the value, and you pay them, you acquire the property, and they can sue you for claiming that you didn't pay them enough. And if the requisite percentage between what you paid and what the court ultimately approves is, don't hold me to this, 15 to 20%, then they get their actual attorney fees. Now, that was very quick. That was off the top of my head, the procedure that needs to be followed in a condemnation. And I did so only to give you sort of a sense of what is to occur. There were properties in the city of Milwaukee, for instance, when they created the bus terminal that the people refused to leave. They had to go through every step of the process, including removing the people physically removing the people and their property after the condemnation. So that's, as I said, it's because the legislature felt that what occurred in Milwaukee County, mainly to acquire those lands, was not protective enough of the property owners, that they wrote this very detailed step-by-step process that must be followed by municipalities in order to condemn property.
Okay, now, can I ask a question there?
Sure.
So if there's a property for sale and the owner wants to sell it to the municipality, what is the first step? That the seller has to approach the municipality?
Yes, and this is what occurred over on Highway 164. The property owner, first, let me give you one caveat before I answer that. I wanted to make two more points just as I've indicated, we have an interest with your property. I'm sitting in a building in the village of Sussex, which is a classic story. Attorney Dan Fay called me one day and he said, John, we know that in order to build the new village hall, you need my client's property. I said, that's correct. He said, how does it work? I go, well, we either condemn it or we have what we call more of an informal condemnation. It's still a condemnation. We still do the initial resolution to commence the process, but instead of going through all of the appraisals and everything, the property owner sends us a letter and says, I am willing to sell you this property for blank. And I said to Attorney Fay at that time, if your client wants to do that, please document how you reach that value, because we as a government body cannot pay more than the value of the property unless there's some justification for it. So he actually went and had appraisals done, and he detailed all of the reasons to justify the price, and ultimately, it's public knowledge, the board met in closed session, and they said, albeit it's higher than the assessed value, we can justify that to our taxpayers that is the price. Now, why do I tell you that? Because you cannot negotiate the price. You can only accept the price or reject the price. I can make a counter offer on other things other than price, meaning, that they gotta empty it, or they gotta let us inspect it, or they gotta, we can do an environmental impact statement, things like that. And I think we did counter for the properties on 164. I thought they wrote, correct me if I'm wrong, someone in the room might recall, I thought they sent us a letter, they said, we're willing to sell you those properties for X amount of dollars, and then we do the formal counter offer to make it a contract, and as part of that counter offer, we include their condemnation rights and ask them to sign off on the condemnation, the formal condemnation process as part of the counter offer. So I put a lot on the table there, so let me break it down very quickly. It starts by you giving them an indication that you might be wanting that property. You indicate to them, we cannot negotiate price with you. The price you send is the price we have to accept or not accept. Don't play games with us. You have to say that politely, but I do believe that that's what you're saying to them, is don't play games. Don't come back, 50,000 more than it's worth, expecting us to counter it, 10,000 more, and then you'll go 30,000. It doesn't work that way. This is not a normal real estate transaction and purchase. This is an up or down on the dollar amount, albeit we would do a formal counter offer. And I think in the 164 situation properties, they actually submitted an offer and I submitted a counter offer. And that's how we made the contract. But many of the people just send a letter saying, I would be willing to sell you this property for blank. And then the board meets in closed session. They decide whether or not they want to accept that number or not, or reject that number. If they accept that number, they direct me to do a counter offer, making it a contract.
John's Bob Stigler. I got a question. You said before that if they come up with a price and they tell you what it's going to be, you can say, the board can say no to that. Can they come back with another price later on then and say, we'll sell it to you for this then, or not? Is that considered another counter offer?
No, they can come back. Every day they can come back $5,000 less until they hit the magic number. I've never seen that actually done, but the law does not, there's nothing in the law since we're sort of making, I don't mean this in a negative way, because I've done this dozens and dozens of times, so it's not a made-up process, meaning that I just make it up each time, but it is a process. So if you submit and if they submit and you politely say no, they can come back next week with a lesser amount. Yes.
Okay.
There's no stopping that from occurring.
It just sounds like we do this buying in reverse on a normal real estate transaction.
Bob was saying it seems like we do the buying in reverse of a normal transaction.
Well, I mean, when you make a offer, yes, you're absolutely right. They make you an offer to sell instead of you making an offer to
questions?
And I've seen it, as I said, I probably do 2 or 3 of these a year. Our office does.
Right,
So it's not totally uncommon.
right. Okay,
I tell you, we do far more of these than we do formal condemnations.
right,
Because most communities do not condemn properties. They only acquire properties that people are wanting to sell to them.
right.
But we have, this is where of course we have to condemn or we can't do the road or we can't, do the project.
Okay, I don't see any other questions, so let's move on to bidding for something